While this video series 104, we shall continue to discuss the types of borrowers part 2, which is based on JAIIB paper 2, Principles and Practices of Banking Module B, Functions of Bank, Unit 22. In this channel, various credit lending topics based on JAIIB and CAIIB latest syllabus will be discussed in simple language through small videos. It is certain that those who have read and understood the topics covered in the videos will find it very easy to appear in the JAIIB and CAIIB and DBF examinations. The founder of this channel is a retired banker with 36 years of experience. He had served two banks for 28 years. He also served as a senior faculty and consultant with a reputed bankers training college for 8 years, teaching mainly the lending topics starting from basics of lending to advanced credit management. He still continues to be a freelance trainer in banking subjects. Now, the leftover types of borrowers are the partnership firms, companies, Hindu undivided family, and limited liability partnership. Today we shall be discussing partnership firm. The Indian Partnership Act 1932 governs a partnership firm. Section 4 of the Act says that a partnership firm is a relation between persons who have agreed to share the profits of a business carried on by all or any of them acting for all. The relationships between the partners is governed by the partnership deed. Besides, the dealings with the partnership firm are governed by the Indian Contract Act. Legal position of a partnership. A partnership is not distinct from its partners. Section 18 of the Partnership Act reads, subject to provisions of this Act, a partner is the agent of the firm for the purpose of the business of the firm. The Indian Partnership Act 1932 provides for registration of a partnership but does not make it mandatory. It should be ascertained whether the firm is registered or not. Authority of the partners. If a partner does an act in the usual course of business of the firm, then his act binds the firm. This authority of the partner to bind the firm is implied authority. Section 19 of the Indian Partnership Act 1932. Section 22 of the Indian Partnership Act 1932 adds that the acts which was done by the partner to bind the firm must be done in the name of the firm or in any other manner which implies an intention to bind the firm. Any partner in a trading partnership has certain limited implied powers. These are power to borrow money on behalf of the firm for the firm's ordinary course of business, power to sell or pledge any of the partnership property. A partner in a non-trading firm has no such implied powers except possibly in the drawing and endorsing of checks. A partner cannot give guarantee on behalf of the firm unless it is in the activity of furnishing guarantee, that is usual practice of the particular trade. A partner does not have the authority to submit a dispute to arbitration or to commit his partners to being partners in another firm. Essential ingredients of a partnership firm. There must be an association of two or more persons, does not include firms. Two partnerships cannot enter into a partnership, although all the partners of the firms may form a separate partnership not exceeding the prescribed maximum number. As per section 464(1) of the Companies Act 2013, the maximum number that can be prescribed is 100. Currently, as per the Companies Miscellaneous Rules 2014, the maximum number is 50 for a partnership to do a business of gain. There must be an express or implied agreement between the partners to do a business for gain. There must be a business, that is a trade, occupation or a profession that must be legal. There must be sharing of profits and losses of the business, except for distinct understanding for some partner sharing only profit but not loss. The business must be carried on either by all or by any one of the partners of the firm. These entities are not partnership, a society, an association, a club, a joint Hindu family, a co-ownership. Registration of a partnership firm. Need for registration. The Act contemplates the registration of a firm and not the partnership deed. The Partnership Act does not provide for compulsory registration of firm. So mere non-registration would not affect the carrying on the business and giving effect to the partnership deed. But certain constraints from which an unregistered firm could suffer encourage partners to register firms. Registration is evidence of the existence of partnership. Partners of a registered firm cannot deny existence of a partnership firm, hence affording protection to outsiders dealing with the firm. It is also in the interest of partners themselves to have the firm registered, else if the firm's registration is not done, then the firm or any other person on its behalf cannot file a suit against a third party or against any partner of the firm for breach of contract which the firm has entered into. Procedure. Application for registration of a firm is submitted within 1 year of forming to the registrar of firms with a statement in the prescribed form along with the firm stating name of the firm, place or principal place of business of the firm, names of any other place where the firm carries on the business, date of joining of each of the partners, names in full and permanent addresses of the partners, duration of the firm, length of time for which the firm proposes to conduct the business. Certificate of registration. Registrar records an entry of the statement in the register of the firms, files the original statement and grants the certificate of registration. Also, any change in and the dissolution of a firm and also withdrawal of a minor are recorded. Rectification of mistake. The registrar can rectify any mistake in the entry in the register of firms. Rectifications can be in respect of any place of business omitted or name of any person wrongly noted, and these do not affect the registration. Inspection. The registrar of the firms, the statement, notices and intimations filed with the registrar are open to inspection by any person on payment of a prescribed fee. Copies of entries. Any person can obtain a copy of an entry or portion in the register of firms by making an application to the registrar and paying prescribed fee. These entities are conclusive proof of the fact as against any person by whom or on whose behalf such statement, intimation or notice was signed. Penalty. Any person who signs a statement, amending statement, notice or intimation which is false or incomplete that he knows or believes to be so is punishable with imprisonment up to 3 months or with a fine or both. Consequences of non-registration of a firm. 1. Suits by partners inter se. A partner or anyone on his behalf can institute in any court a suit against the firm or against any other partner of the firm to enforce a right arising from a contract or conferred by the Partnership Act, including a claim of set-off or other proceeding for a right from a contract. Sued by a firm against third parties. No suit to enforce a right arising from a contract, including a claim of set-off or other proceedings to enforce a right arising from a contract can be instituted in any court by or on behalf of a firm against any third party unless the firm is registered and the persons suing have been shown in the register of firms as partners in the firm. The bar under this section applies to rights arising out of a contract only and not in respect of other rights like the right to enforce a contract embodied in a negotiable instrument, right to eject a landlord, right to determine the liability of the landlord, etc. Exceptions. There are two exceptions. The enforcement of right to sue for dissolution of a firm or for accounts of a dissolved firm or any right or power to realize the property of the dissolved firm. B. The powers of an official assignee, receiver or court under the Presidency Towns Insolvency Act 1909 to realize the property of an insolvent partner. Business of partnership form, how it is done. Rights and duties of partners. Rights and duties of partners are determined by the deed of partnership. It provides for opening of bank accounts, borrowing powers, signing of checks, etc. Generally, the managing partner conducts the business on behalf of other partners. A banker dealing with a partnership firm should ensure that the business is conducted as per the partnership deed. If the managing partner does not have the powers to conduct certain transactions, then it should be ensured that the consent of all partners are obtained. B. Partnership firm and transactions in immovable property. Section 19 of the Indian Partnership Act 1932 states that a partner cannot affect the transfer of immovable property of the firm unless expressly authorized. When firm's immovable property is offered as security, it should be ensured that the partner creating the mortgage is expressly authorized or all the partners jointly create mortgage. The memorandum of deposit should be signed by all the partners. A partner does not have implied authority to act on behalf of all the partners in executing a mortgage deed. Section 19 of the Indian Partnership Act 1932. In case of legal mortgage, concurrence of all partners is required either in the mortgage deed itself or in a deed authorizing a partner to execute the mortgage deed on behalf of him and other partners. Insolvency of the firm. On receiving the notice of insolvency of the firm, any further transaction in the account must be immediately stopped, irrespective of the account being in credit or debit. In case of credit balance, if the banker does not intend to set off the same against the dues in any other account, it has to be handed over to the official receiver appointed by the court or as directed by the court. In case it is in debit, the bank would be required to prove the debt before the court and thereafter will be entitled to receive payment from the official receiver either in full or as per the dividend declared by the court. Insolvency of a partner. If at the time of insolvency of one of the partners, the firm's account is in credit, then the other partners can operate the same. The bank should obtain a fresh mandate and previous checks issued by the insolvent partners may be paid only if other partners confirm. In case the account is in debit, then further transactions in the account should be stopped so that the rule in Clayton's case does not apply. Clayton rule deals with the appropriation of payment for discharge of debts. Under the Indian Contract Act, the debtor has the right to appropriate the payment in case there is more than one debt due to the creditor. The debtor making payment has the right to direct the creditor to appropriate the payment to discharge his debts. Death of a partner. The death of a partner dissolves the partnership firm. Hence, upon receipt of such information, banks should stop the transactions in a running credit facility like cash credit overdraft to crystallize the liability of the deceased partner and make his her estate liable for its dues. Bank may allow the transactions in a separate account so that the business of the firm is not adversely affected. Dealing with a partnership firm. While entertaining a loan proposal of a partnership firm, the following requirements are important. The firm should be a registered one. Scrutinize the partnership deed for any provisions that may put the loan into jeopardy. If one of the partners is a limited company, bank's charge should be registered with the registrar of companies. So we have learned the one of the types of borrowers, the partnership. Subscribe to my channel, which is totally free of cost. Subscriptions will give you intimation on the new videos published. More videos based on JAIIB and CAIIB syllabus based credit topics are to be published. Thank you very much. Your YouTube channel is NPIS Learning Modules in Lending. Thank you.